समझ नहीं आ रहा अपने सैलरी इंक्रीमेंट का क्या करूं।
बेटा इतना क्या सोच रहा है? अपने म्यूचुअल फंड्स के एसआईपी का टॉप अप करा ले। दिस इज द राइट टाइम।
क्या समझ में नहीं आया?
बेटा इतना क्या सोच रहा है? अपने म्यूचुअल फंड्स का एसआईपी टॉप अप करा ले। दिस इज द राइट टाइम।
आप समझा?
Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
Umar Khalid, accused in the Delhi riots case under the UAPA, has been denied bail by the Supreme Court, who granted conditional bail to 5 of his co-accused in the same case. The Supreme Court suggested that Umar Khalid and Sharjeel Imam had a different gravity of allegations against them, and hence their cases must be treated differently. The Supreme Court also argued that a delay in trial was not quote unquote a trump card when it came to the application for bail. Umar Khalid has been in jail without trial for 5 years. I'm Barkha. You're with the Mojo story. On the program today, we look at the Umar Khalid case, a case that has fiercely divided opinion in India, with many arguing that it points to a kind of crunching collapse of India's judicial system, because why should anybody be in jail for 5 years without trial? Others say that the allegations are extremely grave. They connect to the Delhi riots case, and both Khalid and Sharjeel Imam are being tried under the UAPA. The Supreme Court agreed with that line of thinking today. The court granted bail, conditional bail, to 5 of the other co-accused in the same case, but said that it will not be granting bail to Khalid and Sharjeel Imam. It prima facie focused on the gravity of allegations against them in the Delhi riots case. It also argued that a delay in the trial, it's been 5 years without a trial, did not qualify as a basis for bail in this particular case. These developments come even as there's another parallel row brewing, because American lawmakers have written to the Indian envoy in the United States on this particular case, and the newly elected celebrity mayor of New York City, Zohran Mamdani, has sent a handwritten note for Umar Khalid through his father, whom he met with in New York. This act has also riled the BJP, as have the comments and the letter made or sent by US lawmakers to the Indian envoy in the US. By the way, even as we're discussing the Umar Khalid case, a case in which there has been no trial for 5 years, guess how certain other convicted prisoners are treated? The man you see on your screen has been convicted for rape, Ram Rahim. He's out on his 15th parole, a 40-day parole, a 15th parole since 2017. He was meant to be serving a 20-year sentence in prison. And it is this contrast in images that often makes people wonder, does the law apply equally to all? Not to compare apples with oranges, but even so, the question must be asked. Let me introduce our panel of experts today as we look at how the Supreme Court has responded in the Umar Khalid case. I'm joined by Susie Ben Shah. Susie Ben is, of course, a member of the ruling NDA, but she's also a trained advocate. So it's always good to see you, ma'am. Welcome to the program. I'm joined also by, we're very pleased to have with us Justice Sanjeev Banerjee. He has been the Chief Justice of both the Madras and the Meghalaya High Courts. Namaskar and welcome to the program. Also joining me is Senior Advocate Percival Bilemoria, one of India's best-known lawyers. It's always a pleasure to have you with us, Mr. Bilemoria. And also joining us is Sanjoy Ghosh, another well-known lawyer, extremely outspoken senior advocate of our country. Was expecting, I think, a different verdict, a different response from the Supreme Court today, and was blown away, as you can see from his comments on X, at the order that finally came. I must, in the fairness of things, start with Justice Banerjee. You are somebody who's had to be on on the bench that today we're talking about. You've had to try cases, you've had to look at law, you've had to, in a way, put emotion to one side and look at a case. Now, when we look at the Umar Khalid case and not getting into the allegations, whether they're true, false, just looking at the fact that he has not had a trial for 5 years. And today the Supreme Court said that they could apply for bail after another year, once a certain phase in terms of documenting the witnesses was over, and that the delay in trial by itself did not qualify them for bail today. Did you agree, Justice Banerjee, with the response of the Supreme Court?
Two things. The Supreme Court has interpreted certain facts and has come to a conclusion based on those facts. Now, my interpretation could be different, but once it's interpreted those facts to find that a strong prima facie case had been made out by the prosecution, it's justified. Because we do not get prompt trial in this country, it does not mean that every person whose trial is delayed must, as a matter of rule, be enlarged on bail. Thirdly, and most importantly, and despite the caveat that I may have seen things quite differently, just to justify what has happened, because let us not belittle the highest court of our country. Let us not, denigrate the institution to that extent. What the Supreme Court says is that till the witnesses are examined or that the investigation to that extent is complete, they should not be let out. Now, one of the considerations in granting bail is to what extent would the accused be able to influence the evidence that has to be gathered or the process of investigation. So it has given reasons which are in tune with the principles to be followed. But as to the interpretation, of course, you and I may think differently from how the Supreme Court has.
Can I, before I open it up, just push you a little bit to make sure I've understood you correctly? I think what I'm hearing you say is that the Supreme Court has taken a bunch of information before it and interpreted that information to make the case that there's a prima facie case made out against Umar Khalid and Sharjeel Imam that is somewhat different in gravity from the five co-accused who've been granted conditional bail. I think what I'm hearing you say is you personally probably would have looked at that information differently. But once the Supreme Court has looked at it in this way, they have a legal basis to do what they've done. Am I correct?
Absolutely.
But you would have looked at the information differently?
Probably, possibly. Two persons may not agree. And considering the other circumstances, their status, their ages, I would definitely have looked at it differently. But, if you rely on a principle, then it's fine.
Sanjoy Ghosh, let's bring you in, because I know from your comments on X, unlike Percy, who hasn't expressed an opinion yet publicly on this case, that you were shocked. And that I think you expected a bail to be granted, maybe with a list of conditions, but that conditional bail was for the other 5 accused. Now, Justice Banerjee, I think, pretty much indicates that he would have looked at the available information differently, but any judge has the right to look at the information placed before him or her in a certain way, and the judges haven't gone against the principles of law in their response. I'm assuming that you think they've gone against the spirit of the law.
Barkha, thank you for having me. Well, most interestingly, this judgment has enlarged some people on bail. So it's not that people have not got relief today. So what is interesting is to see how has the Supreme Court differentiated those who were denied, namely 2 people, Umar Khalid and Sharjeel, and those who have got the bail. The Supreme Court now lays a very important principle. The Supreme Court says we are not going to go by a general bunch of facts. We are not going to go by the general conspiracy. We are going to see the individual roles of each of them. Now, I'll just take a minute. The Supreme Court has listed out in para 158 what is the individual role of these 2, Umar Khalid and Sharjeel Imam. And they are, 1, creation and administration of mobilization platforms, basically WhatsApp groups, dissemination of written material intended to galvanize participation, meetings and coordination, and public exhortations for articulating a strategy of disruption. So this is what is being held against them. Now, the Supreme Court seems to indicate that these people, or accept the prosecution case, that if a person, in the course of trying to create a pressure tactic on the government, trying to create an agitation, if you set up a WhatsApp group and you make exhortations. Now remember, none of these exhortations are exhortation to violence. Neither Umar Khalid or Sharjeel Imam has said desh ke gaddaro ko goli maro salo ko. There is no such exhortation made of violence or doing any kind of harm to any person. What is at one stage, the Supreme Court quotes the statement made by Sharjeel Imam. He says that I'm going to we can chakka jam and we can chop off northeast out of India. Now let us take it that Umar Khalid and Sharjeel Imam are the most disgusting people on earth. We don't have to like them. This is not a case of a liking contest. Okay. Now let us assume that Umar Khalid, Sharjeel Imam said, we can do a chakka jam and we can cut off northeast or Assam. Let us assume Umar Khalid or Sharjeel Imam pleads guilty to this offense, that yes, we said this. Now, we all know nothing has happened. We all know no northeast was cut off. Now, what is the sentence any reasonable judge would have given a person who has admitted and confessed to this offense that yes, I said this? It's a very bad thing. Would you sentence him for more than 5 years imprisonment? So that is the point over here. What is now, having said all of this, you are letting out and enlarging some people on bail. And for these people, you are saying apply after a year. Why after a year? Either you stick to your principle that this is a special law which you spend 40 minutes.
So Sanjoy, you're saying even if the speeches or some speech attributed to Sharjeel Imam is considered inflammatory, it didn't result in violence, and therefore it cannot be seen as inciting violence?
I'm not saying so. I'm saying even if it is a speech inciting violence, if there is no chain to show that the Delhi riots are directly related to this, for that inflammatory speech, I think even if he's convicted, 5 years imprisonment is more than justified and sufficient for that person who has made such a speech.
And you're saying here they are 5 years without a trial.
Without a trial, without charge sheet being framed. And the Chief Justice is here. Ask him that when charge sheet is not framed, when there are more than 10, 20 so-called protected prosecution witnesses, you think it is practical that a trial will, or this witnesses recording will be over, charges will be framed, and everything will be done within a year?
Brief response there, Justice Banerjee, before I come to Percy and Susie Ben. The fact is that Sanjoy is making 2 points. One, that they've already spent as much time in jail as they would have probably done had they been convicted. And two, is this really a finite time of a year?
Probably not. Probably not. If it couldn't be done in 5 years, how can it be done in the next year? How can you be certain? Why should they have to wait another year before they apply? Why not 2 months down the line? And why exactly after a year? These are, things which probably are somewhat left to interpretation. But the fact remains that certain grounds have been given. Those grounds are pegged to legal principles. Now you can always, distinguish the grounds. You can always take a different view, but the grounds are at least pegged to the principles relevant for considering or granting bail.
Are you comfortable with how the judiciary has handled this case?
No, not at all. If we must allow dissent. We must have a year out for what the other side says, and drumming up support for opposing something that you do not believe in per se is something which is not actionable or should not be actionable in a civilized society, in a responsible democracy.
Percival Bilemoria, let me bring you in. As a sort of legal luminary, how do you look at it? Do you think the courts have come out well? I think it would be different if the courts had ruled on guilt or innocence. I think that is a very different debate. I think what most people see is just a dragging on of a case that doesn't get tried.
Well, Barkha, that's a separate issue altogether. So let me just get to the root of the matter. And what you are seeing here is order in a SLP from the decision of the Delhi High Court. And I would commend anyone to read the excellent judgment of Justice Naveen Chawla, where he gets down to the law in case of UAPA. I think it's a very fine exposition of the prevailing law. And essentially, the crux of the matter is that there is a section in that UAPA, 43D, and section 5 says very clearly that bail will not be granted. So it's a negative section. In a negative sense, you will not grant bail if on examination of the case diary, you find that there is a prima facie case against the accused, or rather it says that prima facie, there is reason to believe that the accusations are correct.
Right.
So that is the thumb rule. And I think Justice Chawla's judgment goes a step further to say that this is the legislative mandate. And he also says that this, in a way, the exercise of discretion, because at some level bail is discretionary, but in his opinion, and I tend to agree with this, the court's exercise of discretion in granting bail is circumscribed. So there is a statutory mandate that the courts are following. Now, the mandate, as I said, is look at the case diary, look at the facts on record. Look now, of course, I think we have charge sheets. So there are, aspects in the charge sheet that can be looked at. And if the judge comes to a decision that, look, in my opinion, there exists a prima facie case, then you cannot grant bail. That is the mandate of the law. Now,
so you're saying that the court has to interpret the law, and the law allows for the fact very specifically that if there is a prima facie case, then no bail will be given under this particular UAPA law.
Exactly. Also, you see, the thing is, we must remember that the case against these gentlemen is one of conspiracy. So, they have been called as the intellectual architects. Again, I'm referring to the Delhi High Court decision. The intellectual architects of what transpired. And we must remember that these are not just ordinary rioting, not protest. And I think we heard that in court today when, it was mentioned before the court that violence in the name of protest is not free speech. This, according to the prosecution, is a case of premeditated violence. And the two kingpin conspirators are the two gentlemen who have been denied bail. Now, again, if you look at the Delhi High Court judgment, that bench looked at various material on record. They looked at speeches, witness statements, call records, and similarly concluded that they do believe that there is a prima facie case against them, and therefore did not grant bail.
But you heard what Justice Banerjee said, Percy, briefly, because Susie Ben is waiting, that on the letter of the law, the court has done something that he doesn't disagree with, but on the spirit of the law, he may have looked at it very differently.
Yeah, but I think, the question is that, do we really need such draconian laws? I think that is a question that we must first debate.
Yeah.
See, various governments, across the spectrum, I remember, there was Misa and Coffee Posa and various draconian laws that have been enacted by several governments from time to time. Now, I think before we we blame the judiciary or point fingers at the judiciary, I think there needs to be a debate about the need for these kind of laws. And I think, this law pertains to terrorism. Now, we live in a very difficult neighborhood. And, if you are asking me, I would say that yes, for the crimes of terrorism, I do believe that we need such a law. So let me ask you a question. So, if you look at, the Bombay 2008 incident, which is still fresh in my memory, would you grant bail to someone like Kasab?
No, of course not. Of course not.
Now,
but I would want to try him and put him away and hang him as he was as soon as possible in a finite timeline. Because if the conspiracy allegations are as grave as they have been, Percy, in this case, what is this 5 saal without a trial?
No, but you're again looking at the time factor, which I think, I think all there should be quite consensus that look, time is to be taken into account. It normally is taken into account. I mean, the courts will say, okay, well, there are so many witnesses. How much more is he going to languish in jail till all the evidence is over? But please remember, this is a special law. And again, I'm saying that this is a special law. Has it been challenged? And the constitutionality of such a law is a different matter altogether. As far as the courts are concerned, they are following the letter of the law. They are doing what they are mandated to do.
But all of you, including the Supreme Court today, seem to suggest that the timeline, the delays are not relevant to how the court responded. Susie Ben, the ordinary citizen doesn't understand that. I understand that for the ordinary citizen, there are, under trials who have waited much longer. But the fact is that if we are talking about terrorism, if we are talking about riots, if we are talking about conspiracy, then all the more, in my opinion, this case should have been tried a lot earlier than it has been. In fact, it hasn't yet been tried. That's question one. Question two, the ordinary citizen sees a Ram Rahim, a convicted rapist and murderer, who, by the way, when he was taken away, I don't know how many of you remember the kind of violence that his supporters unleashed on the streets of Punjab. He is out for the 15th time since 2017 on a 40-day parole. And people see the contrast and they wonder, does the law apply equally? Susie Ben, I want your response. Could you unmute yourself, ma'am?
Yeah.
Yeah.
A very good evening to all. And this, Barkha, I would just like to say this as a common layman, as a social and political activist, and also a trained lawyer, that this is under a UAPA, right? Under the UAPA Act, where bail is a privilege and not a right, right? In most other cases, bail is a right. Jail is not a rule. Bail is everyone's right. But UAPA doesn't exist that way. Secondly, what are we talking about? This is not a simple riot, not a simple stone pelting situation. This organized activity had national and international ramifications. There was a conspiracy. A particular community was targeted. It went on for days. There were 50 people who lost their lives. There were blockades systematically done to ensure that the fire, the lifesavers like ambulance, the lifesaving systems could not reach the spot. So therefore, the Supreme Court, in their wisdom and the facts before them, have opined in the manner that they did. We must appreciate the fact that the 5 people who were co-accused, maybe they were not involved in the conspiracy, were given bail. So I think it should be heard very, very clearly that he wanted to, this Tukre gang. I think the entire and ensuring that the Northeast should secede from India. It was Tukre. They were known as Tukre gang.
How do you respond to Sanjoy Ghosh's reference to it's a political question, that there are those linked to your ally, the BJP, who gave slogans, "Desh ke gadaro ko goli mare o salo ko." There was also that. I'm not making a case for Sharjeel Imam's speech at all. I'm just saying that the law did not deal with those speeches as sternly as perhaps it should have.
No, 2 wrongs don't make 1 right. I appreciate. So what I'm trying to tell here is, but that speech did not result in riots, 50 people losing their life. There was not a conspiracy. This was a systematic conspiracy to mobilize people to incite violence. It was an election speech that the gentleman made. I don't remember his name. Here, it is the worst riots that Delhi has ever witnessed, Barkha. So many people lost their lives, and therefore, I think it should not be taken lightly. The bail was denied systematically over years. He was given bail to attend, I think, the wedding of his sister. So there is sentiments involved. But here, I think the Supreme Court has opined correctly, and such speech or UAPA, whether UAPA should be there, should be removed, that's a different debate altogether. But as long as the act is there, it should be applied systematically and equally to all. Now, 5 people were given bail. Now, the Ram Rahim matter, then you can't compare this with Ram Rahim. right? Whether
Why not?
he was given
Why
bail.
not? Why not?
Because we are not under UAPA. This is a national security, public law and order.
I understand, but I don't want Ram Rahim to enjoy the impunity that he does even after getting 20 years in prison. As a citizen, I'm allowed to say, why is this man getting
You're
his
right.
15th parole? 15th parole since 2017, a 40-day parole. He's an extremely powerful man. His victims are still out there, right? We saw now, you came and very passionately spoke, and I'm glad what you said happened. The CBI did appeal the High Court's decision
yes.
And I'm glad you said this. Justice Banerjee was there, and we both appreciated your saying that. But yes, I understand that the two cases are different. I understand one is rape and murder, the other is terrorism. I understand that, ma'am. But it feels like Rahim is powerful, so he gets this kind of treatment, right?
No, I think there are no emotions. Honorable Lordship will agree that as far as law is concerned, there are no emotions, there are no sentiments. It's the letter of the law. The act that is in UAPA bail cannot be given. It's an exception. It is an exception.
Okay.
It is an
Let me get Justice Banerjee. Yeah, sorry. Complete your point.
Ram Rahim manner, while I do appreciate that he should not have been given bail, but you see, the act says there in that particular case, bail is a right.
Okay.
Is a right.
I get what you're saying. You're saying you and Percival have both made the argument that the law itself interprets and allows for very different responses by the court. And I think that's a fair legal point.
Only one more statement, Barkha. It was timed
Yes.
when there was an international delegation. It was done purposely, specifically to undermine our security and to ensure that we were shown as a kind of a state where our national security was compromised. Nationally and internationally, there was a
and therefore I prefaced it by saying I know I'm comparing apples and oranges. I'm not trying to draw an identical likening between rape and murder on the one hand and national security issues on the other. But I do think that in those Delhi riots, there were other inflammatory speeches that were made as well. And many people might ask, what happened to all of those cases? Now, one of the controversial things has been, why did it take so long? And one of the most debated statements has come from the former Chief Justice of India, Justice Chandrachud. I know Sanjoy has commented on this. Others have commented on this. I asked Justice Chandrachud that because he said to me, A to Z. He said to me, A to Z, I gave everybody bail. Meaning Ornab was his A and Z was Zubair of Alt News, Mohammad Zubair. And then I asked him about Umar Khalid, and I want to play out this statement and then come right back for reactions. Take a look.
So what happens is, what the layperson sees is a Ram Rahim who is standing trial for rape, getting multiple parole visits because he's politically powerful. And in Umar Khalid, this is what the layperson sees. Now, this may be, as you've explained it, the lens of that particular judge, the lens of that particular court. But there seems to be a great unevenness in which this principle is applied. Would you concede that?
Not really. Now, since you mentioned Umar Khalid's case, and I don't want to comment on the merits of the case.
Yeah, I'm not commenting. I'm using it as an example.
But I must tell you one thing which is lost sight of by a lot of people when it comes to Umar Khalid's case. Can you imagine that the case was adjourned? There were at least 7, if not more, adjournments which were sought by the counsel appearing for Umar Khalid, and eventually the application for bail was withdrawn. So what do you have to say to this? That when, on the one hand, lawyers appearing for the accused repeatedly ask for adjournments of cases before a judge, and then you withdraw a case, can then everybody, can a segment of the bar or civil society say, or they must be at least told that, look at the record. Here was a case where someone appearing for the accused has repeatedly sought time before the court. Why? Why this reluctance to argue a case? Either you argue it on the first day or you say that, well, I don't want to press my application for bail. I'll reserve my application for bail before the High Court or before the District Court, as the case may be. But in Umar Khalid's case itself, if the record is seen, it would show that repeated applications for adjournment was made before the court. Now, at the end of it, what happens is, particular perspective is conveyed on the social media and in the media. Judges have no place to defend themselves. And if you look at really the fine print of what happens in the court, reality is a little more nuanced than what happens.
Okay, I want to get Sanjoy Ghosh because he may speak more freely than I think Justice Banerjee might about a fellow judge. Let me get Sanjoy here. What Justice Chandrachud seems to be saying is that Umar Khalid's legal team kept applying for adjournments because they weren't comfortable with their case coming up before a particular judge or A judge or B judge or C judge, which takes us back to the master of the roster debate. The Chief Justice of the country is the master, of a particular court is the master of the roster. The problem in our legal system is it's so judge-centric. It's not like the American system where there's a precedent and the precedent is applied equally. What did you make of Justice Chandrachud there arguing that Umar Khalid's own team is partially responsible for the delay in his trial or lack of trial?
See, firstly, Barkha, the statement that the judges don't have a podium to defend themselves is incorrect. Now you have chief justices on retirement coming to Arnab's show and defending their judgments. So that era is over, first of all. So the judges are doing their PRs. Secondly, Justice Chandrachud's defense is clever by half. I can understand a person who's, let us say, is out on interim bail and is then trying to delay the final decision by taking adjournment after adjournment. The question you have to ask is that what was the benefit Umar Khalid or the other person is getting by getting repeated adjournments when he's actually inside jail? So it's not that he's out on interim bail, he's enjoying the liberty and he's delaying the adjudication of the bail. He is taking an adjournment at the cost of his further incarceration. So that speaks words for the system of justice that you're putting out for him, where he's so scared to even press his bail application. So, and I don't have to tell you why that would happen. Now, the last comment which I want to make is that the polyvocality of our court. You alluded to that by saying certain cases go to certain types of judges. So, for example, in 2024, as recent as 2024, a bench of Justice Pardiwala and Bhuiyan in Ghulam Nabi Sheikh has interpreted the same UAPA which Percy was talking about and has said that 4 years in prison is enough for the appellant to get bail. And Justice Ramanna's judgment before that has said that fine, there is a legislative mandate that you have to have a prima facie view that that no case is made out, but that is at the beginning of a trial. But if the trial is protracted, then the constitutional right to liberty will trump the statutory right of presumption. So you have a polyvocality of court, you have different judgments for different people. In this circumstance, it becomes very important to know why certain cases were being listed before certain types of benches. And that is the answer. You should have, when you were interviewing Justice Chandrachud, you should have said, you tell me, what is the benefit, Justice Chandrachud, what is the benefit Umar Khalid's lawyer is getting by taking an adjournment when he's still in jail and it's his adjudication?
No, it's quite, maybe I should have followed up on that question better. I take that point, but it's quite obvious to me what he's saying. And Justice Banerjee, I don't want to put you on the spot, but basically the argument here is that Khalid's team did not want their case to come before a judge that they felt would not be predisposed to hear them fairly. That seems to be very clearly what Justice Chandrachud is implying. And, it's very uncomfortable for us to basically impute any motive to any judge. So we have to be very careful in how we articulate ourselves. But what did you make of that argument that Khalid himself is responsible for some of the delay in his own case, which Sanjoy says is nonsense?
Utterly confusing and misleading. Take no cognizance of that. The fact remains that, as Sanjoy has said, that no person in jail would want to delay the hearing on the bail application unless absolutely pushed. So let's leave it at that. The more important thing is that this was the Supreme Court dealing with the matter. The Supreme Court has authority under Article 142 of the Constitution. The Supreme Court is not bound by the letter of the law. The Supreme Court should also see the sense of justice being conveyed. And this is where I am disappointed. Not in the interpretation, not in pegging the reasons to principles, but in the overall look of it.
And you're disappointed because
do these young people deserve to be dealt with the way they have been, with no future? Does, in every case, the slightest allegation which is uncomfortable require UAPA to be brought in? What security problem are we talking about? Is it a loss of pride which is equal to loss of security? India is not so insecure that, two boys would be able to disrupt or hold it to ransom.
What would you have done? What would you have done if you were trying this case?
I'm happy I haven't. I wouldn't have continued this order. I'm sorry. I'm blunt.
Yeah. So, Percival, let's bring you in. Justice Banerjee, who's served as Chief Justice of 2 different high courts, says, the Supreme Court is not bound by the letter of the law. In fact, its very duty is to interpret the spirit of the law. And the court has to satisfy itself that the spirit of the law, the essence of the law, is being upheld. And he doesn't believe that that's happened here. How do you respond?
Well, so I agree with what was articulated by Justice Banerjee. But you see, let's look at the steep uphill task that the person in the hot seat, which is a judge, has ahead of him. So first of all, this is a case of conspiracy. And as we all lawyers are fond of saying, conspiracies are always hatched in the dark. And it's always a circumstantial case. Now the law imposes on the judge a duty to weigh the evidence, to understand the evidence that is there against the particular accused, and then decide whether there is a prima facie case against him, in which case he cannot grant bail. So it is the mandate of the law. And I think it's a very, my sympathies frankly are with the judiciary on this one. Yes, the accused does get the rough end of the stick. And I think that is also a function of the law. And again, I'm saying that, look, we have to look at whether this kind of a law, some people will say that, yes, we need to have that. I happen to be one of those. There are some who would disagree with me entirely, and that's just a matter of opinion. See, as far as the trial delays also are concerned, I think, we do go on about this, but please remember here there are something like 82 accused. And 82 witnesses, right? And to examine 82 witnesses will take quite a while. And I think that is, in a way, one more reason for the courts to look at it with a little sympathy. And ultimately, it's just in a way, the discretion and the orientation of the bench that is looking at this and saying that should we be exercising our discretion sympathetically or no.
Okay.
Given in light of the evidence that they have seen.
Yeah.
Also, Barkha, this you mentioned this, and I think we should talk a little bit about this. For the mayor of New York.
Yeah, I was coming to that. I
think it's ridiculous, and so to point fingers to our judiciary. So the Americans do tend to believe that they are the salt of the earth, and I think with President Trump we are seeing a little more of that. But I think as a lawyer and an officer of this court, I take offense to somebody saying that, look, please make sure he has a fair trial, right? Because that implies that there could be situations where he will not get a free trial, which I think is extremely offensive.
Yeah. I think I'm glad you raised this. I had opened with it and I was going to talk about it. And Susie, when the BJP, your political partner, has made a lot of sort of comments on this, not just on Zohran Mamdani's handwritten letter, the text of which you see on your screen, but also the fact that US lawmakers have written to the Indian envoy and said that please assure a fair trial. And Mr. Bilamoria says he's extremely offended by that. I want to ask you your thoughts. See, the fact is, I understand what Percival feels like. Who are the Americans? The Americans, Trump is showing that they really do think that they are the police of the world. That said, we live in a globalized world. Everybody comments on everybody. We have opinions, for example, rightfully so, on how religious minorities are being treated in Bangladesh. As offended as Mr. Bilemoria is, can you really close off the world's opinion? This is the reality. You're dealing with sections of, different sections of global opinion all the time.
No, the point here is not closing off. They can say what they have to. We can't put a zip on their on their mouth. But the kind of publicity and the political party, especially the Congress party, tweeting, retweeting, and making a issue out of it. Let us understand, it is our legal system, our judiciary, the third pillar of democracy is undermined, and you are making a political statement out of it. I think such statement by Mr. Mardani should be condemned. He has no right. Maybe he could write, but then to say that no fair trial will be given by suggesting that kindly give fair trial is absolutely objectionable. And all of us in unison, whether the media, of course, you are also the fourth pillar of democracy, should condemn it, because we are well equipped to handle and our national security.
I'll tell you personally, I have no patience for people of another country commenting on the internal affairs of my country. However, just let me complete my point. However, we live in a globalized world, where everybody opinion is free. We cannot stop anybody from expressing an opinion. We have to deal with it. Yes, you agree?
Our own political party is supporting it and making an issue.
Yeah, that's a different point.
There is no politics to it. The issue, Mr. Mamdani is saying, he seems to be the know all and be all of all that is right and all the things that are wrong.
Mr. Mamdani is actually, from what we can tell, is talking about the bitterness not consuming Umar Khalid. It's US lawmakers who have written to the Indian envoy.
No. He's also presupposed saying that he should be given a free trial. And that he was suggestive, just falling short of saying that he should be given bail, just falling short. So therefore, all these things, I think none of us should at least give publicity or fall prey to it. That's what I'm trying to say. And why the Congress party is always found with such people supporting such people, I don't understand.
Sanjay, I want you to respond.
Criminal conspiracy? Is it a larger international conspiracy? Gets you thinking. Especially what happened, a doctor was convicted in that bomb that went out at India Gate. Sorry, at the Red Fort.
Red Fort.
There is conspiracy. So therefore, we should limit ourselves to UAPA, and rely on the wisdom of the Supreme Court. It is not once; it is time and again he has been denied bail, and when it was found necessary, he was been given bail to attend to the sister's wedding. So therefore, I think the honorable justices have opined in their wisdom and as per the law of the land.
Sanjay, Umar Khalid's father is said to have met with Mr. Mamdani, and this handwritten note was sent via him. He obviously probably thought that if people in the West raise their voice, it will create more of an awareness for Insan's case. It may have boomeranged. How do you see this row over Mamdani's letter, the US lawmaker's letter?
Well, Barkha, I think it's a complete non-issue. How our courts are made of much sterner stuff. Our courts are trolled. Our judges are so bitterly trolled on social media in every controversial case. My heart goes out to many of them. They are very bold in dealing with that, the severe trolling. Even the right wing and the left wing, they get it from both sides, as you know, being active on X, that. So if our judges can survive the bitter trolling of our own domestic Indians, a Gujarati NRI in New York is not going to affect the independence and the spine of our judges. But I just want to make a point, because this is a very personal day for me, because I don't know whether you know, I was the lawyer who at 2 at night was in Justice Muralidhar's house when the order was passed in the Delhi riots case. I was representing the Delhi government, or rather the Delhi police at that time. And it is with the intervention of Justice Muralidhar's bench and Justice Bambani's bench that and I got the police over there, and from his house the orders were passed to allow the ambulance to be passageway to be given for the ambulance to bring those people who were shot who were shot and who were not getting treatment. And the point I want to make is that all those people who were trapped there, because Susie Ben's comment that people were being prevented from access to medical aid brought this memory back to me. All those people belong to one particular community, namely the minority community. So therefore, it is amazing that we are talking about a conspiracy of riots, and we have these two student leaders are the only people we have found to place this blame of rioting on. And there's no other person who organized this, who organized the arms, who organized the violence. Where are those people? From both communities. Rioting is not about religion. Rioting is a crime. It is the worst kind of human rights abuse in a country, and no one can stand in defense of any rioter or violence from whichever community they are. And whichever community they are, they have to be given the most stringent punishment. But are we doing that? Is there a sincere will of this government to go to the root of this riot and to even-handedly give justice to everyone? That's the question.
I think that's an important question, Justice Banerjee. Let me give you the closing word. You opened by saying that the courts were within their right to interpret the information before them in a particular way. But is it the complete story? And is it not the duty of the court to get to the full story of who was behind everybody? Maybe these two, maybe they will conclude that they were. But I think Sanjoy is asking, could they have done it alone? Where are the others? Do we know the full story? Will we ever know the full story?
I don't think our constitution or our democracy was designed to suit one particular segment. That's the philosophy of the India that I know, is that all are equal. I may have a different opinion, I may disagree, but my voice will be heard. Increasingly, over the recent years, dissent has taken a backseat. Dissent is not anti-national. Dissent is not revolting against the state. But dissent is necessary for even democracy to survive. And I'm slightly disappointed that courts have not been able to uphold the right to dissent and the right to have a contrary opinion. There, I'm very disappointed. From how certain journalists have been treated by, courts in a defamation action being instituted by powerful capitalists, or how courts have interpreted certain statements the wrong way. I think the court should be much larger hearted and much more charitable and open in allowing free speech and dissent forming part of free speech. There, I think we should do better. But last thing, but just about the thing. The next time an American tells you about justice and about their judicial system, just tell them Dred Scott, and you'll shut them up.
Tell us a little more. Our audience will not know the story. Tell us a little more.
The story is where the US Supreme Court held that a slave was a chattel of the white man and was his property.
Yeah.
Our Supreme Court has never done anything as horrendous as that, or even resembling that.
But one thing I want to add.
Yes.
We are only talking about the accused. What about the victims? 50 people lost their lives. So at least there, we should also talk about their justice, their denial. 50 people. This was not a riot. It was not stone pelting. People have lost lives. So therefore,
on both sides, on both sides.
No, that's true. But there is not a word about them. There's not a word about them. So therefore, I think it should not be we should not be talking about the accused, only the accused, but also the victims, those who've lost their lives, their families, the trauma that they suffered. So therefore, I think we should go beyond the two people who've been denied bail and also talk about national security, protection, and justice for the 50 people who've lost lives.
I'll give Percival the last word. I reported these riots. Some of what the victims went through is very, very vivid in my mind. I still have, all the footage, the interviews of the horror that ordinary people, the poorest segments of our city, actually went through. So I'm all for talking about the victims. However, there is a larger principle that Justice Banerjee has thrown up here, that a right to dissent the right to accept opinions that are inimical to us. And here, Susie Ben, I want to clarify, I'm not talking about involvement in riots. I am not talking about involvement in riots. There can be no right to be involved in riots. There is no right to be involved in riots. There is no right to incite violence. So I think we're all on the same page on that. I think we're all on the same page of telling the Americans to buzz off. I think on a few things we're on the same page. Now let's just come to this last point thrown up by Justice Banerjee, right to dissent, be more accepting, let the courts have a bigger heart about it, even if they disagree vociferously, violently with some of the speeches that come before them.
Yeah, so Barkha, I think, I do tend to agree with Justice Banerjee on this. There have been recent signs that I have noticed about, some attempt to, to prevent people from speaking out or protesting. And in fact, the test of this will now be known day after tomorrow, because there is a bench of the Supreme Court, a special bench, which will now consider whether it will hear interveners who actually were made to pay money to be accepted as interveners and yet were not heard. Now, I think, you are talking here about a case where, arguments were heard, both sides, and there were deliberations. And I think the court has come up with a judgment, which is, in their own view, is probably the right thing. Now, as Justice Banerjee said, others may differ from that. But this case is one where people were made to pay money to be heard, it's never happened in the history of the Supreme Court. That's one. Despite that, the unfortunate fact is that the judgment was just read out. See, we use the word pronounce, right? Pronounce judgment. What happened here is that the judgment was announced. And we are taking it up very seriously on Wednesday. And, I'm very keenly looking forward to seeing what happens there, because this is really a travesty of justice.
And why are people paying money to be heard? Can you explain that bit?
That was it was set out by the court that if you want to intervene in this case and be impleaded as a party, then you have to pay a certain sum of money. And then there are the people who paid money are non-government organizations who work for the welfare of animals, and they could hardly afford to pay the money, but they paid up. And then they were astonished that they were not heard.
Well, lots of questions, I think, for the judicial system in general. I think I only want to say that not many of you seem concerned with the timeline, maybe because you're all lawyers and judges. But for the ordinary person, the whole Tariq pe Tariq culture is actually really a sort of galling thing. And I just want to end with what somebody in our audience, Prasad, has said. Even if we were to agree to the order of the two Supreme Court judges, I would have expected the judges to also order the government to start the trial in no less than 3 months or some immediate time frame. I mean, I don't know if it's up to the government, but could a time frame, could this case, as serious as the charges are, especially because the charges, Susie, are so serious and they're about a conspiracy, why are we dragging our feet as a country on this trial? I think that is certainly something else that we can agree on. We'll leave it there. Thank you very much. It's been a somber debate. It's raised many interesting points of law, but also of democracy, also of responsibility, also of the fact that I don't think any of us have too much patience for lecturing from other countries. We'll say thank you to Susie Ben, to Sanjoy Ghosh, to Percival Bilemoria, and to Justice Banerjee. Always a pleasure. Namaskar, thank you, and see you soon. It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.